In the honor of time, we are going to just go ahead and get started. For those of you I may not have met before, my name is Wendy Zadeb, the Executive Director at the Michigan Association of Secondary School Principals. And I'd like to thank all of you for joining us today on this extremely important and timely topic. I know that we all continue to struggle with the horrific event that occurred at Oxford High School a little over a week ago. And we also continue to mourn for the students and their families affected by this unthinkable tragedy. At this time, before we get started, I would like to start with a moment of silence in memory of the 4 students who have passed away and for those who were wounded, as well as all of those who continue to be affected by this terrible and sad event. Thank you. While we continue to reflect on the Oxford tragedy, we need to shift our focus a bit closer to home to ensure that our own districts and buildings are safe environments for students and staff. In addition, we need to be proactively prepared, both operationally and legally, for all the unpredictable events that might come our way. As you're aware, and some are experiencing, copycat threats are making the rounds, keeping every school administrator on edge. This just goes to prove, once again, that in today's environment, we never know when a similar situation might happen in our own building. I appreciate that so many of you have taken the time to join us for today's webinar at this critical time in public education. I'm going to turn it over to MASSP's Deputy Executive Director, Colin Rittmaster, who's going to do introductions and who's going to facilitate today's webinar. I'll remain on the back end monitoring the chat and the question and answer.
Thank you, Wendy, for your leadership during this very challenging time for principals around our state. Your voice, your advocacy, your listening ear are valued not only by the team at MASSP, but all of our members throughout the state. So thank you for that leadership. Thank you for being so reliable and present in our workplaces and within our hearts. As we go forward, remember this will be a panel discussion. And as we go through the panel discussions, there'll be opportunities for you as participants, local building administrators, central office teachers, other leaders that are with us today, to post questions to get clarity as we go. So for that, please do use the Q&A function as we go. Following this, we will take the recording and the slide deck, and we will push that out through our weekly headlines that go out Monday mornings at 6 a.m. Please note this webinar is recorded and will be posted on our website. The information provided in this webinar by MASSP and the panelists with us today are advisory in nature and reflect general legal standards and are not intended as legal advice for specific situations that you might face. For future legal developments may too, as legislation comes and other interpretations by courts come, may affect future outcomes. But in the immediate and what we're dealing with right now, these are based on what we know of as today. We want to make sure that as building principals, you seek out the advice and counsel of your district leaders and your own legal counsel who are able to address specific situations. With that, I want to welcome Kevin Sutton, our friend, our colleague, our partner from Miller Johnson, who's been with us for years. For being with us, and he's going to provide us some legal perspective, some of our legalese, we often refer to it, and address from that question. In addition, we have our partners from the Michigan State Police, both Lieutenant Scott Layman and Sgt Carlos Fossati. They're specifically in their roles with the OK to Say program and the intelligence. And so when things come into the Michigan State Police through OK to Say, it's their department that vets the threats and facilitates the communication with both local law enforcement and with school officials. And so after Kevin provides some context for what we're doing today, and we proceed through that, both Lieutenant Layman and Sgt Fossati will address questions and walk you through kind of how OK to Say works, how they vet threats, and how we can work closely with our law enforcement to ensure that our students, staff, and communities are safe places for all learners and their families. So with that, Kevin, why don't you start us? I mean, where do you even begin? As Wendy said, challenging times and critical pieces. So where do you begin? What would you have to say to us as words of wisdom?
Yeah, thank you, Colin. And I don't know if I have words of wisdom. I have a lot of words, and I will be happy to share them here over the next little bit. And I just want to echo Colin's comments. Thank you to Wendy and her team for showing leadership on this front, as they always do on so many others. And it's a tough time right now. And I want to be really clear. And many of you, obviously, I know work with directly. Our representation is on behalf of school districts all over the state of Michigan. And yes, I'm an attorney. And that's why I'm here. But I'm also Lauren's husband, and I'm also Kendall and Garrett's dad. And my wife, as many of you know, is an elementary teacher here in Metro Detroit. Both of my kids are still school aged. I've got one who's a freshman in high school and one who's in 6th grade. And it's been a difficult week. It's been a difficult week as Lauren's husband. It's been a difficult week as Kendall and Garrett's dad, on top of it being a difficult week plus as counsel to many. And so we're all hurting. And we're all scared, and we're all trying to figure out how to navigate not just this reality of what happened so tragically in Oxford last week, but the other realities that we've been dealing with now. And I think, any one of these realities, COVID for the last 20 plus months, the disciplinary situations we've seen really explode the first 3 months of this school year. Now the situation in Oxford, any one of these by themselves would be a monumental task for us to confront as a school community, to confront as administrators, to confront as attorneys. Dealing with all three of them at the same time almost seems unfair. It almost seems unfair to ask us to try to manage all three of these monumental tasks at the same time. But that is what we have been asked to do. And as educators always do, you get up every morning and you do the absolute best you can to continue to push ahead, looking through the lens of what is best for kids and how can we best support the students in our buildings. And the odds, it reminds me of the Hunger Games. May the odds be ever in your favor. They don't seem like they're in our favor right now because there's so much that we are managing on a daily basis. And that is obvious, right? I think everybody knows what we are dealing with, what the last 20 plus months have looked like from a student trauma perspective, from a staff trauma perspective. The challenges of being remote, being in person, face mask mandates, quarantine guidelines, the inability to kind of have a normal school day, what we've seen manifest itself with student behaviors these first few months of the year. And I'm here to tell you that if you're seeing an increase in disciplinary situations, if you're seeing an increase in student incidents, you are not alone. Everyone across the state is facing these challenges. These challenges no zip code. They are not isolated to urban areas. They're not isolated to certain demographics. This is happening in every single school community across the state. Last year, I don't think I had a single expulsion hearing. Now, obviously, there were a lot of kids who weren't physically in school. I've had more at the beginning of this year than I probably did in the 3 years prior already, and it's only December. And that is because of all of the things that have happened. How do we move forward? We're trying desperately to move forward. We want to move forward. We want to get back to normalcy. We want to protect kids. We want to do what is best for them. It's hard. There are a lot of days it's hard as legal counsel, many days to hear it. And I'm not on the front lines like you are, dealing with students, dealing with the trauma that they faced. And there is a temptation, I think, particularly in response to what we saw happen last week in Oxford. And that is to say, well, we're going to get draconian. We're going to go back old school. We're going to get iron fisted in terms of how we deal with student behaviors. And certainly there are some behaviors that warrant that. Obviously, the copycat things that we've seen the last week, those things need to be dealt with a very heavy-handed way. And certainly law enforcement, prosecutors' offices are taking that approach. But what about the other stuff? The other things that happen and are happening at a really an exponential rate that disrupt the school day, that make it difficult for us to focus on teaching and learning, which is already difficult with everything going on. We've got to fight the temptation, I think, to do that. We've got to sort of stick with our mantra, which we're going to talk about from a disciplinary perspective in terms of our 7 factors, in terms of restorative practices, in terms of trying to address the significant trauma that our students have experienced. And when I say significant trauma, I don't just mean Oxford, which of course would be significant by itself, but all of the trauma of the last 20 plus months, and all of our students have experienced it. No matter how hard we have tried, no matter how supportive moms and dads have been at home, it's been difficult for all of them, no matter how much support they have had. So we're dealing with all of these things, this somewhat toxic cocktail that we have to drink on a daily basis and still move forward. But there is good news. And I promise you there is some good news in all of this. And as we're going to talk about over the next few slides and over the course of our time together about moving forward and how to do that in a way, thinking about liability and thinking about student safety and all those things. I know we got 169 people on this Zoom right now. I am 100% confident, without being able to see all of the faces, that all 169 people on this call get up every single morning with the exact same mission, and that is to do everything they can for kids and to do it to their best effort, to do it with a full heart, to do it in good faith, and to do it with a student-centered focus. And that compass, that mission, that ethos is what is going to carry us forward. And as we look at some of these things about liability and exposure and discipline, that mantra is going to continue to ring true. Getting up with that focus on a daily basis on our students and doing the absolute best we can do is going to mitigate some of these things that we are very concerned about, understandably, as we try to operate in this environment. And so as Colin and I talked yesterday, sort of where to begin and how do we analyze all of this madness in a thoughtful way that makes sense and gives people somewhat of an idea of what to kind of hang on to and what to think about, and hopefully to ease some concerns. The question that I know MASSP has gotten quite a bit in the last week, and I certainly have gotten it many, many times, is about liability, right? Legal liability. You know, Kevin, that's great. We're here every day. We're doing our best. What happens if we make a mistake? What happens if we miss something, right? Hindsight is 20/20. We all know that. We've all heard that phrase. And as it relates to recent events, there's a lot of hindsight going on. Well, they should have done this. They should have done that. They should have seen this. They should have seen that. They should have reacted this way. And it's very easy to envision ourselves being in that situation and saying, holy cow, you know, with everything going on, with the against the backdrop of madness that we are operating right now, we're going to try our best to be perfect. But what if we aren't perfect? Am I going to get sued, right? Am I going to lose my house? What does it mean for my kids? What does it mean for my job? What does it mean for those things? And as building leaders, of course, you've got staff that have those concerns and are posing those concerns to you. So I want to start with that. I want to start thinking about this big concept of liability and having legal liability for having done something wrong or having made a mistake. The good news is, and this is the real positive thing to think about, there are limited instances of legal liability. We have, to a great extent, tremendous protection as school personnel when we're doing what we're supposed to be doing on a daily basis. We're operating within the scope of our job, and we are operating in good faith to support students. Generally speaking, when we are doing those things, legal liability is not going to be a concern or be a factor. There's something in Michigan, and I promise I won't go too deep into the woods, called the Governmental Tort Liability Act, or GTLA, we call it. You might have heard the phrase governmental immunity along the way. And what the GTLA generally says, talks about school districts as organizations being protected from liability, and it talks about individual employees being protected from liability. What kind of liability? Liability if somebody is injured at school, right? What we call torts, injuries to individuals. And when individuals are injured, individuals feel that maybe something should have been done to protect them from some sort of injury. Very often lawsuits are brought. They might name the school district, they might name administrators, they might name individual staff employees. And what the Governmental Tort Liability Act does in a very succinct way is wrap you in a cloak of protection to a certain extent. Think about it on it's a super cold day, right? You go outside on a really, really cold day, you want your warmest winter coat on. You want to wrap yourself up in that winter coat. And governmental immunity is that jacket, right? It's not completely perfect, but if you got a nice big warm jacket, it will generally keep you warm on a very, very cold day. The exceptions to governmental immunity as it relates to employees is very, very narrow. The exceptions are very, very narrow. Generally speaking, if you are acting within the scope of your employment, i.e. you're doing the job, right, on a day-to-day basis as an administrator, as a teacher, as a staffer, doing the things that are expected of you as part of your normal job responsibilities. If you are doing that and you're doing it in a way that is not grossly negligent, we'll talk about that in a second, you're going to be wrapped in that cloak of protection. You're going to be wrapped in that warm winter jacket. Well, Kevin, I'm reading the papers and I'm seeing things about gross negligence. What does that mean, right? I mean, obviously, we have a situation where students were severely injured. Wouldn't that be gross negligence because something bad happened? No, not necessarily. Gross negligence is defined under Michigan law as conduct so reckless as to demonstrate a substantial disregard for whether an injury might occur. And I know that sounds very legal, but think about some of those words. Conduct so reckless as to demonstrate a substantial disregard as to whether somebody got injured. I was once in the Oakland County Circuit Court arguing before a judge, and he likened that to driving down Old Woodward in downtown Birmingham with your foot on the accelerator and your eyes closed. That would be gross negligence because you would have substantial disregard for whether anybody was injured. If you think about how you operate, how your staff operates on a daily basis, we're pretty safe from reaching that threshold, right? We don't operate in a way that shows a substantial disregard. Are we perfect all the time? No. Are we omnipotent? Are we omniscient? Can we tell the future in terms of what might happen with a student? Of course not. We have instincts and we try to follow them to the best of our ability. We follow our student code, we follow our district policies, so on and so forth. But we don't have to be perfect. And the law doesn't expect us to be perfect. They expect us to do our job to the best of our ability and operate in a way that shows focus and concern on others, to be student-centered in our analysis. And so when I say that everything that we all do on a daily basis binds us because we all have that vision, we all have that ethos in terms of focusing on students, doing our absolute best, you don't need to be held to the standard of being perfect legally. You might want to be perfect on a daily basis. I think we all do, but we're human and we're not going to be. And so don't be concerned, particularly as you see media reports, you hear things about, well, they weren't perfect. And we're using hindsight. We can show they weren't perfect. That's not the standard legally. The standard generally is that gross negligence standard, and were you acting in a way that showed a substantial disregard. And I will tell you that I have seen very few instances in my career, which started back when I had a full head of hair, of teachers or staff acting in a way that was so callous that it would reach that standard. Has it happened? Sure. It's happened a few times over the course of my career where I've seen that behavior that was that callous, that disregarding of injury to others, that it violated, it pierced that jacket. You weren't able to keep yourself warm and it pierced that jacket and there was liability. But generally speaking, more times than not, there is no liability because it's a very, very narrow exception with a very specific legal definition. And so I want to start there because I think, we naturally have a lot of concern. We naturally have a lot of fear about that. Let's take that out of the equation because we don't need to be thinking about those things. Discipline. What are we going to do about discipline? Whole lot to digest here and a whole lot of sort of things coming at us to think about, right? We obviously have differentiation between general education students and special education students. As many of you know or should know that if we're talking about disciplining a special education student, that can constitute a change in placement, which requires a manifestation determination review before they've been out of school for more than 10 days. And so there are considerations to be there. What are the other things that we're looking at? The legislative mandates. We all know it's all been well chronicled. You've all been trained extensively about the 7 factors that we have to consider before issuing discipline. The rebuttable presumption that our legislature put right in the law against reasonable presumption against long-term suspension and expulsion. Interestingly, and I didn't know this, I found this out thanks to Wendy and her team. The Attorney General sent out a communication. The Michigan Attorney General sent out a communication mid-October of this year, talking about what she perceived to be the increased number of suspensions and expulsions, reminding everybody of their obligation under the law, considering the 7 factors, considering restorative practices. And right in that memo is a phrase which says, suspensions and expulsions should be reserved only for the most egregious behaviors That's from the Attorney General of the state of Michigan. And so I know one of the things that we've talked about over the course of the last week is, we need to be suspending more. We need to be expelling more. And they're having this tension, right? This tension with the 7 factors, having this tension with the idea of restorative justice, restorative practices, and trying to keep students in school. That, to me, is the biggest challenge that we face right now. I will tell you, as I said, in the first 3 months, the behaviors that I'm seeing are unbelievable. More cases of egregious student behaviors than I've probably ever seen in a full school year, and it's only December 7th. I would never dismiss any sort of bad student behavior, but I'm not talking about student fights or somebody calling somebody a name. I'm talking about egregious instances of sexual contact, sexual violence. I'm talking about weapons on campus, time and time again, dangerous weapons. I'm talking about significant fights, multiple students ganging up and inflicting severe bodily harm. I'm seeing it at a prolific rate, and I'm sure many of you are as well. It's easy to say, okay, this is what we got to do, but why is it happening? I think we all know why it's happening. We've got students who have suffered trauma. We have students who don't have soft skills. They have very, very limited interpersonal skills. They don't have conflict resolution skills. They don't know a lot of their classmates because they haven't been at school. And despite our best efforts, we have a lot of administrators who don't know the students yet because we haven't seen them for a couple of years. Things that under normal circumstances, we might see something bubbling and be able to jump in and stop it. We're not there yet because we don't know the kids, despite trying and doing everything we can to connect with them and establish a relationship. So that's part of the reason all of these things are happening. And I think in many instances, a lot of these kids are probably 2 years behind from a maturity standpoint, what we would normally see. And so we're seeing this is all of the why for the egregious behaviors. And I think we're at a point, and Wendy, Colin, and I were just talking offline before this started about what do we do? I mean, on the one hand, as human beings, we know that restorative practices are a good thing. We know that adolescent brains don't necessarily understand everything that's happening. And we know the trauma they've been through. We know the immaturity that's there. And we know in many instances, the last thing they need is to be sent home. What they need is to be here with us, learning on a daily basis, having some structure in their lives, getting back to some degree of normalcy from an educational perspective. And the tension right now is we can know all of that. But I'm in a situation where what I see as legal counsel is almost like a Lord of the Flies situation where the students are, in many instances, out of control. And again, through no lack of effort and trying on administration's part, but these egregious behaviors continue to happen and we cannot lose control of our buildings. We simply cannot. And so I think there is this existing tension between these things. Wendy?
Kevin, I think every single administrator that's on this webinar is ready to yell amen and charge up the hill behind you, because you hit it right. You just hit it out of the park. That's exactly how things are. And that's how everyone's feeling. And, you talked about the really egregious behavior, but in addition to that, I mean, the every day of a building administrator's, things they're dealing with at the building on top of all the COVID type issues. But it's also, vaping is through the roof. Everybody is just really struggling with that. And then even those, just fights. I'm hearing from principals, things that they might just be an out of school short-term suspension. So it might not get to your level, but, principals are saying even at the middle level, the amount of fights and hostile interactions between students and even, the online social media stuff on and on and on, is just out of control. And so I feel like when you paint that picture, certainly it doesn't make anybody say, oh, ooh, good, it's not just me. There is that type of relief, but I just don't feel like the general public has any clue of everything that you just spoke of and the complexity of the decisions that principals and counselors and social workers in a building have to make every single day.
Yeah. Well, amen. And the thing that strikes me is the level of appreciation and recognition there was from our school communities and from our parents at the beginning of the pandemic when they had to face the reality of trying to get a teenager to sit and learn online. And they thought, man, you teachers walk on water. I can't believe how amazing that is. And it's odd to me how quickly that has evaporated. That understanding has evaporated now that the kids are back in school. And families and parents have been through a lot as well. And certainly there are those in these communities that understand and appreciate what you all are facing on a daily basis. But I agree with you, Wendy, wholeheartedly. I don't think they necessarily understand what's happening or the awesome responsibility that sits on the shoulders of a building administrator. I mean, yes, when you have something as horrific and terrible as what happened in Oxford, we get a lot of attention for a few weeks, right, about safety and copycat crimes and all that. But your obligation to maintain safety is there every single day. And I know in talking with all of you, it's what drives you every single day, even when there's not a horrific incident happening 30 miles up the road. And so I agree with you that parents don't necessarily understand, but I think we've got this really fine line to walk. And obviously going back and reading the Attorney General's comments about 7 factors and restorative justice, all good things. And we're not just going to get, again, draconian and start kicking kids out of school, but we also can't lose control of our buildings. And I don't think that was ever the intent of the legislature, was to have us lose control of our buildings. And so I know a lot of you probably feel guilty with the number of disciplinary issues you're having, or recommendations for long-term suspension or expulsion that you might be having. I know you're making those decisions seriously. I know you're contemplating the 7 factors. I know you're looking at the situations in and of themselves. We're going to fight the temptation to just do it automatically. We're going to be thoughtful. We're going to take an individualized approach with all of these things, but don't be afraid. Don't be afraid to issue discipline as is necessary. One thing we're hearing a lot about now, though, is constitutional issues. We hear that a lot with First Amendment rights. We certainly have heard a lot this past week about Fourth Amendment, which prohibits illegal search and seizure. And obviously, there are some dynamics to these things that we need to be mindful of. Obviously, from a due process standpoint, we need to process student discipline in a timely way that comports with due process requirements. But those are all things that we're thinking about. And again, it's a very difficult cocktail that we have to choke down right now, but we've got to continue to try to do our best while maintaining control of our buildings. Colin, let's jump to the next slide. And I did allude to search and seizure. And I think, one thing that has been interesting to me, and again, when a horrible situation comes, there's a lot of media scrutiny, there's a lot of reporting. Hearing some of the commentary and questions from the media about search and seizure, I will tell you that it's not quite as easy as the media makes it sound. Search the bag. Why don't you search the bag? Why don't you do this? Why don't you have metal detectors? Why don't you yada, 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 right? And it's not that all of those things aren't generally available as a resource, but generally speaking, with respect to search and seizure, there's a 2-step analysis that you do before you conduct a search as the school. I know the officers are going to come on and they have a different standard because they're the police, but from a school perspective, when it comes to conducting a search, we generally do a 2-step analysis, and this is based on a Supreme Court case. Number 1, do you have reason to believe that the student violated the student code of conduct? In other words, do you have a reasonable suspicion that they did something? If the answer is yes, then do I have reason to believe that where I'm going to search might produce evidence of this violation? And so it's really a 2-step inquiry. And I won't get into commenting on specifics that have been reported in the media, but if you think about that and those 2 steps, it's not as easy as has been suggested perhaps in the media about how you go and search student belongings, search student bags, search student personal possessions. And sort of a rudimentary example I would give you is if you heard over the walkie-talkie, hey, somebody in a gray pullover who's got a beard and is dazzlingly handsome just stole a MacBook from the library. And all of a sudden you see me walking down the hallway, okay? And I'm obviously wearing a gray shirt, beard, and you say, hang on a second, Kevin, I want you to stop there. Now, do you have reason to believe that I might have violated the student code of conduct by stealing something? 100%, right? I fit the description of what's been reported. So you say, Kevin, empty your front pockets. Well, can there be a MacBook in my front pockets? Probably not. I know Mac makes some smaller stuff, but not a MacBook. So me emptying my pockets, let's say I take my pockets out and out falls a vape pen, out falls drugs, out falls whatever. There's an argument to be made that that's not a permissible search because you didn't have reason to believe you'd find a MacBook in my pockets. Now, if I got a backpack on and you say, Kevin, I want to search your backpack, that likely is going to be found to be a permissible search because we've met that 2-step inquiry. I won't spend a ton of time on this, but my idea here is that it's not as easy as you just sort of run around as the media has sort of suggested in the last week, digging into student backpacks and tearing open their lockers and having them empty their pockets and do everything else. It's just not that simple from a legal standpoint because of this pesky thing called the Fourth Amendment. So just be mindful of that. And when we conduct searches, or if we want to have some sort of broad-based policy in place that addresses under the guise of student safety, that there are certain constitutional and legal limitations to doing that sort of thing. And we need to be thoughtful about that before we just head off because the media said we could do it. We need to be a little bit more thoughtful about that. We're going to talk over these next few slides. Colin was kind enough to put together some language that we think will be really helpful, talking about things like threat and assault and weapons and nexus to the school environment. What do those mean? Where do those expectations come from? One thing that I've heard a lot of is sort of help. We don't maybe necessarily have everything we think we need from a student code of conduct standpoint, maybe from a board policy standpoint, maybe from a student handbook standpoint. And so we'll look at a couple of excerpts from our legal survival guide, which is a joint MASSP Miller Johnson production. And I did put a little asterisk there. I don't want to be a cheesy car salesman about it, but it is a resource that we have available to us, certainly to take a look at. So a couple of these things, and we'll move through these quickly. And obviously the slide deck will be available post-presentation, but give an idea about what is a threat. We see from some Supreme Court language, a true threat is a statement where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. We see that language coming from a Supreme Court case in 2003. What's tricky about that is the intent part is what's difficult about dealing with threats, since it can be difficult to tell exactly what another person has in their mind when they make a statement. I had a call from a call from a client yesterday asking about this idea of intentionality. And in a criminal law world, they talk about having the mental intent, the mens rea. We talk about in criminal law about formulating an intent. I think intent for our purposes often means something a little bit different. If I intended to do something, if I intended to communicate, if I intended to act a certain way, but oh my goodness, I didn't intend that consequence. Is that still intent? Very likely it still is intent. And so obviously looking at situations and trying to find out whether or not students are acting intentionally. A lot of you have that language in your policies. A lot of it have that language in your student code of conduct, that if a student has intent, or they have to have intent in order to be disciplined, intent for our purposes, from school purposes, is something that's a little bit more forgiving than we might see in the criminal context, where they're looking at the statute from a criminal liability standpoint. Next slide. Language here referencing this is from the Michigan Criminal Code, what a credible threat is. Means a threat to kill another individual or a threat to inflict physical injury upon another individual that's made in any manner or in any context that causes the individual hearing or receiving the threat to reasonably fear for his or her safety or for the safety of another individual. And this is the type of language that our police officers, our prosecutors are looking at right now with respect to these copycat threats that are being made. A lot of times people are, in most of these instances, students are saying things either because they think it's funny or they lack total context or what have you, but it causes a significant disruption. It strikes fear, it causes fear, and that's why these things are being dealt with as crimes by the prosecutors and by law enforcement. Next slide. So this idea of assault is one that we've gotten a lot of questions about in the last couple weeks, last week in particular. Verbal assault, physical assault, a couple of different things to look at in terms of what they might mean. Both generally are prohibited by law. Both generally should be prohibited under your student code of conduct as behavior that we're not going to allow, and behavior that is not appropriate. Dangerous weapon is a phrase that has an extensive definition in the revised school code. And that's why you see some of these words that maybe you're not familiar with, but a firearm, a dagger, a dirk, a stiletto, or a knife with a blade over 3 inches in length, a pocket knife operated by a mechanical device, an iron bar, or brass knuckles. One of the questions that we get very often is, how do you measure a knife? Does it include the handle and the blade? We're measuring the blade specifically. And if the blade is in excess of 3 inches, that's what makes it a dangerous weapon. Not to suggest that blades under 3 inches aren't dangerous. Of course they are. And of course we don't want them in the school setting either. But those are things that come into play. Some language here to give you some ideas of language that we might see in a student code of conduct. under dangerous weapons, look-alike weapons, or personal protection devices, language that if you don't have it in the student code of conduct can be inserted into a student code of conduct. As you see, the dangerous weapon language largely parallels what we see in the statute. Look-alike weapons have the potential to cause just as much disruption when they're identified, when people think they have them. Obviously, they can't inflict the same level of harm as a weapon, a firearm, but look-alike weapons can also cause tremendous disruption in the school environment. So I want to limit those. I will tell you, personal protection devices is something that I'm seeing an increase in over the course of this school year. A lot of students who are concerned, particularly female students, concerned about walking from the bus to home, carrying pepper spray, carrying mace, carrying other things. I had someone with a taser not long ago because they're concerned for their safety. It's not that I don't understand those things. It's not that I don't understand those concerns or that I'm unsympathetic to them, but those are not things that should be in school. And it's hard when you're confronting with a mom and dad who say, well, what are we supposed to do? I can't get my student to or from school. They've got to ride the bus and we don't live in a very nice neighborhood. She's got to walk home. What am I supposed to do? I wish I had a panacea. I wish I had an answer for that. And I don't know what the answer is, but I do know that you can't have those things in school because it poses a threat to other students. Next slide, Colin. Thank you. A lot of what we talk about is this nexus to school, this connection to school. And this comes up in a lot of different instances. We're obviously talking about a disciplinary context here, but we see it as it relates to First Amendment things, commentary that's made on social media over the weekend between students, things that are posted obviously outside of school hours. They're not posted on a school network or a school device, but they're out there in the world. We see this in instances of Title IX compliance and instances of sexual violence or assault that might happen between students. We're generally looking to see if there's some connection to the school environment. If there's some connection to the school environment, we can generally deal with it. We can generally address it. If there's zero connection, I mean, no plausible connection whatsoever, I don't want to just throw my hands up and say we can't deal with it. At that point, I generally encourage us to be proactive, whether it's having counselors reach out to students or have a conversation with them and try to get in front of situations before they might occur. Yes, it's just one more thing that the school has to worry about. But I generally, even in the absence of a nexus, want to try to be proactive and have proactive conversations with students as opposed to saying, well, there's no nexus to the school. It's not really our problem. When we do that, it's amazing how these things end up on our front lawn. Even though we think there's not a nexus to the school, they very often tend to manifest themselves, particularly student-on-student behaviors. Colin, next. So, and I'm not going to read all of these, but we'll walk through this very quickly because I want to leave ample time for our friends from the Michigan State Police. We talked about the legal survival guide. Again, this is not a petty sales call, but we have this resource available where we talk about student code language, policy language, administrative regulation manuals, and guidelines, forms, all of these things that you can use to make sure that your district is, if you'll excuse the phrase, fully armed against the onslaught of things that we are facing from a student standpoint, so on and so forth. And so we've got language on, as you see there, improper communication and what are the types of comments that students can be disciplined for, what are the types of comments that they should not be making. Next. And Colin, we'll go through relatively fast in the interest of time here. What constitutes a threat, our interaction with police for investigations and arrests, and providing notice to moms and dads when those things happen. Obviously, a laundry list of things where there might be a need to involve our police liaisons and our partners from law enforcement. Obviously, a pretty extensive list there on things that might come up. We have all of those things listed in the legal survival guide. Search and seizure, again, sort of talking about what I alluded to. This is more general language. You see in that second paragraph, personnel may, to the full extent permitted by law, search and seize students and their personal effects. It's that to the full extent permitted by law is the two-part analysis that I was just talking about. But again, the idea here is to give you a roadmap, to give you resources to lean on if you don't have these things spelled out. A lot of questions recently in the last week about FERPA, disclosure of personal information, disclosure of information without consent from parents, and obviously, working with our partners in law enforcement when there is a threat of some kind or an imminent danger or perceived imminent danger is an exception to FERPA, and are things that we can share if it's in the health, safety, and interest of our school community at large. And so I know we tore through those fast. Those will all be on the slide deck, which can be shared. But just know that if you're sensing, hey, look, in the last week, aside from the anxiety that I have and aside from the challenges that we're facing, I really don't feel like our code of conduct or our policies or our processes are really well locked in. That's something that I think we really need to look at as a building, as an organization. Know that MASSP is there, as they so often are, with resources to support you with on these specific topics of student behavior and discipline. With that, I will yield the floor. Thank you.
Thank you, Kevin, for addressing so many of those questions that are front and center to us, but also providing us just a perspective of taking a breath and stepping back and recognizing that some of the things we worry about because we don't know and because of what we hear aren't as great of a threat to us as we might have thought, and that we need to be thinking through things in a rational way. And with that, our partners from the Michigan State Police, I just want to thank you, Lieutenant Layman and Sgt Fossati, for being with us and the work you do to help keep us safe and informed. As Kevin said, he's seeing more in the last 3 months than he maybe has in the last 3 years of suspension expulsions, because kids have just, the executive functioning skills of doing school, of being in a community, and those other skills have eroded in many cases and not had that. And I'm sure, and I know I talked to Scott yesterday, I think he said something that you've had more tips in the last week through OK to Say than you've had in the last 5 years over the system, or something to that effect. And so I guess if you could take some time to share with us from your perspective at the state police, a statewide perspective, knowing that there's local and countywide law enforcement as well, but what are some of the things you're seeing in obviously the copycat threats and so on, but then how might we use the OK to Say a hotline to help support us in keeping our schools safe, and how did that work?
Yeah, sure. Thank you, Colin. And that was great information that Kevin gave us. A lot of the stuff as far as I thought school officials had carte blanche to no expectation of privacy for students in schools. So I'll make sure I don't tell my grandkids that, though. So yeah, the last 7 days, it hasn't been the most over 5 years, but what we've seen in the last 7 days, we've had 2,685 tips come in the last 7 days. To give you perspective, year to date to November 30th, January 1st, November 30th, through that time, we had received 2,688 tips. So in 7 days, we've received 10 months worth of tips. And it's affected, we've had over 140 schools that we've received threats on. So we've been pretty busy this past week. As far as copycats, we take each threat, whether it's somebody sending in a tip on somebody that has a gun, or a suicide threat, or a fight threat, or a bombing, a planned school attack threat. We take those on face value as what they are, and we try to vet those as best we can. We reach out to the person submitting that information if they've given us send in contact information, to try to get as much information, actionable information as we can, and we'll contact schools and pass that along. If it's during school hours, it's going to the schools first and then to law enforcement. If it's after school, we're going to contact law enforcement first, and then the school after hours emergency contact if the school has one listed. But again, as far as copycats, I would hate to say what we're passing along as a copycat. Now, what we are seeing some recirculation of social media posts that started on the 30th and the 1st over in Oakland County. A lot of it refers to threats against CHS schools or FHS schools, things of that nature. The hit list, those are now being recirculated outstate. to other schools. And we are contacting the schools to let them know that your students are reporting this tip, but this tip has come in a week prior, and it most likely doesn't affect your school, but the school administrator should know that their students are submitting this information. It's going to, come with other issues that hopefully they can get out in front of. How does the hotline work? Again, it's the student safety statewide tip line that anybody can submit threats to schools, students, or staff, and it comes in a variety of different media. And again, we try to vet that information and gather as much actionable information as we can before we pass it along. Everything that we get, we pass to the schools, except for the person submitting their PII. So that is confidential by state law. We cannot divulge that to anybody without a court order. Carlos, do you have anything that you want to fill in there?
Yes, thank you, Scott, and good afternoon, everyone. And yes, Kevin, good information. My children will be very better informed because of it. So yeah, the way we receive tips are through 5 different ways. We're phone call, text, through the web, OKC application, as well as the email, and all that comes into our technicians. In regards to us contacting schools, the school is always the best source, obviously, to send a lot of things to, because many times you will have all the information readily available to discern whether or not that tip is legit or if it's not. But when the schools aren't open, we do share that with law enforcement. And to hit on Scott's part, we do contact school after hours contacts so that we can inform the schools well in a timely manner. This brings a point in that it is so important that we have your school's after hour contacts on file. And I'm sorry to say not every school has that. I know you all are under a tremendous lot of pressure and you're asked to be everything under the sun, a cop, a social worker, a teacher, a priest, whatever. Everybody wants everything from you. And I'm asking you to fill out a form and do that twice a year and send it to us for your after hours contact information so that we can forward that on to you. And the copycat threats, the things that we were seeing, it's not so much copycat. Sometimes it's somebody using someone else's creativity, I guess you will, in a negative light, to use it in a way to leak their potential intent. And that's up to you and working in cooperation with your law enforcement agencies and discerning whether or not that's a legit threat or not. And I would add, though, that the information that you receive is the information that my technicians have received to pass along to you. And I got to tell you, as a police officer, it's very vexing to see with very little information. And I'm sure you all are the same with that. You're wanting more information so we can do a better job at digging into that. We always ask, the who, what, where, how, and why. But we don't always hear that back from our tipster. But if you feel in the course of your investigation that you would like some additional information, you may certainly contact us back and talk to a technician and ask them, hey, can you ask the tipster X? And we will certainly ask that for you on your behalf. We can certainly do that. It's just we can't give you that the tipster information so you can talk directly back and forth because of the law, like Lieutenant Layman had explained there. So that's all I currently have. Scott, back to you.
Yeah, I think, Colin, as we talked to yesterday, I think our time might be better spent if answering questions from your audience, if they have any for us.
I think part of what you mentioned is, so although the tipster is anonymous, whatever information you receive other than their name, you're going to pass along to school officials. One of the things that I think sometimes school officials are wondering is what kind of vetting has taken place. And if I understand it correctly, you don't vet the threats or assess them to determine the significance of them or not. It's more you take the information and pass it along from the OK2Say technician directly to the school official during instructional time and to law enforcement after school hours. Can you clarify that or confirm that understanding?
Right. We don't do any threat assessment on the threats we receive per se. Our vetting is trying to gather as much information and intelligence on this threat as possible. So when possible, they're looking into online open source searches, social media posts that may be coming, others that may be coming in related to this issue, that type of thing. But as far as assessing the actual threat itself, we take those on face value, and we're not necessarily the investigative unit. We leave that up to local law enforcement to do.
To Kevin's point earlier, when he talked about credible threats, if there's intention is really a big piece of that. And so if that comes into us, we don't need to be concerned about the FERPA and sharing things with the law enforcement, because if we believe that's a threat, we can partner with our local school liaison officer under the exceptions of the FERPA piece. Kevin, do you want to expound on that at all, or is there anything to clarify that way as far as that, as these come in, your recommendations? Because right now that liability piece of did they act enough or substantial enough is looming out there.
Yeah, no, I think you said it well, Colin. I mean, obviously, look, the idea under FERPA, and I've always, and it's not a direct parallel, but we sort of think of HIPAA, right, in our medical information, and we're not allowed to, doctors' offices can't broadcast our medical information all over the place. I've always thought of FERPA kind of that way, right? I mean, individual educational records, educational information for a student can't be broadcast all over the place. If it's going to be shared with somebody, it's somebody who has a legitimate educational interest in seeing that information. If we are in a situation where we have a threat, a perceived credible threat, if we have a not manufactured, but a credible threat to the health, safety, and welfare of our students and our school community, sharing that information with law enforcement is always going to be fine. We certainly don't want to play FERPA police when we have a threat. We want to make sure that we are responding in the interest of the entire school community, and not because we're super hyper worried about FERPA. And I am worried about FERPA, of course, in the general sense, and we obviously want to adhere with FERPA. But at the end of the day, and I know this is being recorded and it will be posted, but a FERPA violation is not the worst thing in the world. We obviously want to follow FERPA. We want to do what we have to do. And these situations that we're talking about are generally going to be exceptions to the FERPA protection. But if we're not sure, if it's on the borderline and we end up violating FERPA, I will tell you the world is not going to come to a grinding halt legally.
One of the things as building administrators often is part of our work is in working with children, we're trying to determine, is this a criminal piece that needs a legal referral, or is this a mental health cry for help, and how that goes. As a question came in from Dan asking, can you provide any recommendations for those mental health referrals that school follow? And if that recommendation's been made in the past, is there any piece from that from a legal side that then needs to be brought forward? So that question there, or other information that you could provide for additions. We have seen the recommendations from the current situation being mentioned as a touch point in many articles. So I think there's a piece there that as an administrator, you might recommend something, but is there really a requirement? Can schools require, if you will, even the mental health pieces? And so speaking to that, balancing the mental health and the criminal or safety issue.
Yeah, and I want to be really clear for everybody on the call. I have not commented specifically on anything relative to the facts as we believe we know them out of the Oxford situation. It would be inappropriate for me to pass any judgment on the legal liability or lack thereof in the Oxford situation. So please don't take any of my comments to be reflective of that, other than my criticism of the media that's suggesting that searching students is like somehow a piece of cake. I think a couple of things on mental health. I've heard from a lot of special education people in the last week about their fear over doing risk assessments, doing threat assessments, and being very concerned that they're going to make the wrong call. Right. And the conversation that I've had with them has been consistent with what I shared with you earlier about the Governmental Tort Liability Act, the protection, the governmental immunity, the big parka of protection that we're wrapped in, and that those folks should continue to show up to work every day do their best work to the best of their abilities and make the best calls that they can make. I understand that might sound a little bit optimistic. It might sound a little naive, and I understand it does not meet the media story that's out there right now. But I think at the end of the day, that's exactly what we need to do. We don't need to live in fear of being held liable. We shouldn't be doing our job any different than we've always done it. There's not been some portal to insight that's been opened up as a result of this terrible situation. We're going to continue to do what we've done. The protections that were there before last Tuesday will continue to be there thereafter. And we should continue to press ahead, being student-focused and student-centered in what we do, knowing that we're operating in good faith. If we have somebody who blatantly disregards, ignores, glaring red flags, light flashing problems, which would, in my mind, be more egregious than some that have been reported in the media, that's a different story. That's a substantial disregard. But we don't need to reinvent the wheel here because of what has happened. The protections that are there will continue to be in place. The other thing I want to say is this, and Wendy made a really good point earlier about maybe parents in the larger school community not understanding. I think one thing we can all agree is that this situation is a multidimensional problem, okay? And one of the dimensions of that is mental health services, mental wellness, mental supports. The problem with that is the community at large hears mental wellness or mental health, and they don't think about the general population. They think about extreme examples, right? Someone who they think is just Looney Tunes or acts like they're Looney Tunes, foaming at the mouth, uttering indecipherable phrases. Mental health and mental wellness is a much broader category. And I'm here to say with a fair degree of confidence, every one of our students needs social and emotional support right now. No matter how great mom and dad have been at home, no matter how great their network has been, no matter how hard our administrators and teachers have worked, all of the kids need mental health services and social and emotional support, not in a formal psychiatrist, psychologist way, but in a having a community, having structure, having support. And so when we think about this multidimensional problem and we say mental health or mental wellness, it's not just this sliver of percentages off on the extreme of people who we think look like they're Looney Tunes. It's everybody. And it's our staff members as well who need those measures of support. And as we move forward as a community and we continue to have discussions about this topic, we need to understand that mental health is a really, really broad topic that has basic steps in it, like supports from counselors, support from school social workers, so on and so forth.
So
Well, I think along with that, Kevin, that something that we have to, once again, communicate to the public is when we talk about a school counselor or school social worker, that's not a replacement for therapy,
Yes.
and that those people are not in place to provide individual students with like weekly, biweekly, therapy. And so I think sometimes that kind of concept gets in people's minds that that's what a school counselor social worker does. And so Chad, one of our principals, put in the chat, if we recommend or want to require that a parent takes a student to seek counseling, is that then an expense that the school district has to pick up?
It's a really interesting question. And obviously, and I know nobody enjoys attorney sounding answers of, well, it depends. And it's a case by case analysis. But I think to a certain extent, it does depend. Are we talking about a general education student versus a special education student? If we're talking about a special education student who might have ancillary supports already, those might be things that would be the responsibility of the school. If we're going to make counseling a precondition to coming back, I can see the parents' argument of that the school should be the ones paying for that. I guess it just depends on what the situation is, what the facts are, who the student is, and what type of requirement the school is placing on them as to answer the question of whether or not who would ultimately be financially responsible for it. But I think there probably in many instances is a pretty strong case to be made that if the district's going to impose that obligation, it's the district's responsibility to pony up for it.
Okay.
The other part of that I think is important for Kevin, and you might want to affirm is that, or clarify is that sometimes we put that at a condition and then they don't seek it, and that student's been out of school for more than 10 days. So what are the ramifications of that for a district or an administrator?
Yeah, so that's
those considered suspension days still?
They would be, yeah. I mean, in theory, they would be, and obviously, and I won't. Being mindful of the time, I won't get on my soapbox and talk about student discipline. But we have to be mindful of timelines. We have to be mindful of due process considerations, and we can put conditions on a student being reinstated or a student coming back into school in a very general sense. Those things are okay. They're not outside the pale of options, but we need to be mindful of where we're at from a timeline standpoint, where we're at in terms of meeting our due process obligation to ensure that we haven't violated the student's rights in that regard. If we don't handle it well and we mess up from a procedural standpoint, the well, you didn't get counseling and we told you to argument is going to be a difficult one to make potentially, but those are things that with the appropriate accoutrements we can do within our authority. Yes.
Great. I have just one. I have one quick last question for you. That it could be kind of a dual between a legal question and also from a police perspective. So if we get these threats that come in as a principal, you get the call from your okay to say, representative, or you get a threat that a teacher relates to or what have you, and whose job is it to assess if that threat's credible? Is it like, should immediately the principal go to their police liaison or to their local, sheriff deputy or whatever, if they don't have a liaison, so maybe Kevin, from a legal perspective and from our friends from the state police, is it like, should we be relying on someone from our legal community or from our police community to determine if that threat's credible?
Well, I think one of the things that, and I'll just speak from the practical realities of the last 7 days. Okay. And again, I'm not trying to sound overly optimistic or naive about this. I think the number one component, whatever, and I'm sure Scott or Carlos have good insights on this from a law enforcement standpoint. The number one thing that I've seen be a challenge in the last 7 days is communication. I don't know that everybody has a crystal clear vision or even whether my opinion from a legal perspective matters about who's ultimately responsible for it. But the thing that I've seen be problematic is a lack of communication. I've seen building administrators immediately get information, call the police, and assume it will be taken care of, only to find out 2 days later that the superintendent has no idea that this went on. And of course, who's the one who's answering the calls from the Detroit News and Channel 4? The superintendent. And so communication is a piece. Or I have central office administrators who have found out about stuff and they are very dutifully and in good faith calling law enforcement and having all this communications. And I have building leaders who have no idea that it's happening in their building or that the threat is tied to their building. And so I don't know necessarily what the right answer is, but I do know that what I've seen the last 7 days is communicating within your district team about what the threat is and what is happening is absolutely vital, because you need to present a cohesive and united front to the response, whoever it is we're relying on to do that. And that would be my official answer on that topic.
Yeah, I would just say Kevin hit the nail on the head with that one. Communication is huge. Working with your law enforcement agency in conjunction with the information that you have is going to lead you to the best solution possible. I couldn't have said that any better.
Well, we want to thank Kevin, Scott, Carlos for joining us today. Given the number of questions, I've had a number of emails coming in around liability, and people telling me they've been shopping around for liability insurance and they can't find it and stuff. And so we just want to remind you that with your MASSP membership, for all of our professional members, there's a general legal piece there that's really more about if things that come forward about your district, or you need somebody to represent you as far as something connected to your district to a limited extent, we can provide some services that way. But when it really comes to liability, that's one of the major benefits of the NASSP, the National Association of Secondary Schools, practice and their subscription. It's with that the liability insurance. So the MASSP professional membership that many of you have does not cover liability. In order to get the liability coverage of $1 million, you need to be a professional plus or executive member, because that comes through NASSP membership. And with that comes from the professional services. And so if you're in a situation where any of these types of things were to come up and you're sued, your initial representation typically comes from your district and their district attorney. But there are times where then you get sued civilly for responsibilities in that beyond a criminal piece. And that's where the MASSP can be really helpful for you. So if that's something that's a concern of yours and you're interested in being able to have that liability insurance, and you're currently a professional member or not a member, you can email Sarah at michiganprincipals.org, and she can get you signed up. And the way that liability insurance works is the minute you sign up for membership, it kicks in. So you don't have to wait 6 months. You don't have to wait a year. You automatically qualify for that $1 million of liability insurance. And so to Kevin's point, there's a great level of respect for what people are doing as administrators, and to meet that gross negligence is something that for many of you don't need to be as concerned about, because really that tort liability is already covering you. But for those who just want that peace of mind, kind of like you have car insurance or you have health insurance, it's there if you need it for the minimum amount of cost extra in order to get that MASSP membership. It may be worth your consideration from that. And so regardless of where you are with membership, if you email Sarah at michiganprincipals.org, she can help you to cover that or to address those membership questions. But with that, we want to thank Scott, Kevin, Carlos for being with us to share, Wendy, for all your leadership through this, and to each of you as building principals, assistant principals, directors, what you do matters. And to Kevin's point, when it comes to great intentions, we appreciate what you do, the sacrifices you make personally and professionally. And to something Wendy has been sharing over and over again, make sure you take care of yourself. So my challenge for you today is it's 2:07, we're a little over. What I'd like you to do is log off from this Zoom, park your phone, park your computer, and take a walk around your building. Remind people that great things happen within your school and within your community. It's mental health for you, it's mental health for them. One of the greatest things we can do as building principals is be present, to reassure and let people know that we're in this together. And so I want to challenge you today to stop what you're doing, to take a moment to go and be with the people of your school and of your community. Thank you for being with us this last hour. We wish you well and look forward to seeing you, for many of you, on Thursday, where Ann Arbor Public Schools will be sharing from a crisis response planning and training point of view, as well as a counselor and social worker to talk about signs and symptoms of traumatic, post-traumatic stress syndromes and those types of things, and how we can support those students. So have a great afternoon, and thank you for joining us and supporting MASSP.